Today we have a special treat for you. I've taken some sections out of an excellent video presentation by Paul Clement, the excellent Second Amendment-oriented attorney who argued Heller, McDonald, and Bruen. He's talking to the Federalist Society about two Second Amendment cases that just occurred before the U.S. Supreme Court this 2023-2024 term, specifically the Rahimi case as well as the Cargill Bump Stock case. And I think it's sometimes important to hear from other voices about the Second Amendment and the Supreme Court. And Paul Clement, who's the former Solicitor General of the United States, which means the former lead lawyer for the Bush administration back in the day, George W. Bush, a lead lawyer before the U.S. Supreme Court. Paul's a very experienced Supreme Court litigator, a member of the U.S. Supreme Court bar, and an excellent attorney. He now has his own private law firm, along with another excellent partner, Aaron Murphy. You probably have heard me talk about them in prior videos. And since I thought it might be helpful for you to actually see them perform a little bit, I thought you would enjoy it. So with that said, let's hear what Paul has to say about the Rahimi case.
Let me talk now about the Second Amendment, and I'll title this little section Second Amendment and Friends. Because one case is a pure Second Amendment case and the other one is adjacent. The pure Second Amendment case is a case called United States against Rahimi. The question in this case is whether 18 U.S.C. 922 G8, which prohibits someone subject to a TRO for domestic violence from possessing a gun, is consistent with the Second Amendment. The Fifth Circuit said that this statute is inconsistent with the Second Amendment, violates the Second Amendment, and applying the Bruen history, text, and tradition test. The Supreme Court brought it up, and it said, actually, this is consistent with the Second Amendment in an 8-1 decision written by the Chief Justice, with Justice Thomas in dissent. I think the facts of this case go a long way of explaining why the court decided the case the way it did. I mean, in the universe of 922 G8 cases, which are not a sympathetic universe to start with, this is an outlier. This is a person who got a TRO for domestic violence directly involving a firearm, which isn't a requirement for the statute. You can get just a TRO for domestic violence, and then it triggers the statute. But his initial domestic violence involved a firearm. Then the circumstances in which he was caught having a firearm after that also involved the discharge of a firearm, and that's what he was prosecuted. And the brief period while he was sort of on parole or otherwise not detained before that prosecution was brought, he engaged in no less than 5 separate incidents that involved not just the use of a firearm but the discharge of a firearm. So this is a tough case to love. And, in some ways, it is remarkable and I suppose a testament of the Fifth Circuit's willingness to apply the law even to bad facts that this case was decided in favor of the defendant in the first instance. But once it got up to the court, the court was pretty nearly unanimous in saying this, you could prohibit this consistent with the Second Amendment. I think it is striking, though, that the Chief Justice wrote this opinion probably with an eye to doing leaving a lot of the questions about how to apply Bruen unanswered and not deciding other cases involving different statutes and different facts. And so, although this is a case where the party seeking to vindicate the Second Amendment plainly lost, I think it's a case where the court's opinion doesn't do that much to the existing framework and doesn't add that much to the existing framework. The other thing I'd say about this case, which I think is maybe a way to understand how a case with these facts gets up to the Supreme Court, is in a strange way this case sort of shows the maturity of Second Amendment jurisprudence and litigation. Because in the first couple of Second Amendment cases that got to the Supreme Court, many of which I was directly involved in, they came as a result of plaintiffs' challenges to statutes where it was a declaratory judgment action trying to say the statute is unconstitutional. Since they were plaintiffs' Section 1983 actions, the groups that were helping behind the scenes in these cases could really vet their plaintiffs. They could make sure they had somebody that presented a very nice sort of face for the case. I have a case I'm involved in right now where our client is a former Olympic shooter. I mean, that's pretty good, huh? And so when you're sort of on the offense and trying to develop the first steps of the Second Amendment jurisprudence, that it protects an individual right, that applies against the states, that it's robust in its application. Those cases came up in this kind of plaintiff framework. But now that the court has established that it is an individual right, it does apply to the state and local governments, and it's not a weak sister, weak sibling right, but it actually is a robust right protected by this text, history, and tradition. You can expect that lots of criminal defendants facing gun charges are going to raise Second Amendment issues, and this next wave of cases is likely to be litigated in the context of defendant challenges rather than plaintiff challenges.
Well, that was most insightful from Paul Clement, former Solicitor General of the United States for George W. Bush, President George W. Bush. Now he talks next about the Cargill case, which of course is the bump stock ban case where the U.S. Supreme Court declared it to be illegal, improper, and unauthorized under federal statutory law. Let's see what Paul has to say about the Cargill case right here.
The other case I want to talk about very briefly, which I think is a Second Amendment adjacent case, is a case called Garland against Cargill. This was the case about bump stocks. And I think the really important thing to understand about this case is it's not a Second Amendment case. It involves bump stocks, which are kind of like machine guns, so it seems like it should involve the Second Amendment, but it doesn't. It's actually an administrative law case again. And what happened here is, if you remember back to the terrible shooting in Las Vegas, where the shooting was perpetrated by somebody using a bump stock, there was a predictable outcry after that to say, we need to do something about this. Now, the ATF across Democratic and Republican administrations had long been aware of the phenomenon of a bump stock, which basically takes a semi-automatic weapon and allows it to function more like a fully automatic weapon. So ATF had long been aware of this and long of the view that it did not have the statutory authority to prohibit them. But in the wake of this uproar over the shooting, and all of this potential energy for Congress to do something about bump stocks, the Trump administration said, well, actually, I think we do have the authority under this statute to do this by regulation. So never mind with the legislative process. You can just put that to the side. We'll do this by regulation. And this gets brought up through the lower courts. The Fifth Circuit said, no, this is in excess of statutory authority. It gets up to the Supreme Court. And by a 6-3 vote, the court says, yes, this is in excess of statutory interpretation. The regulation is invalid. I think it's kind of a miracle this wasn't 9-0. I mean, this was a pretty straightforward case where the statute didn't obviously provide this authority, and there was a long history across administrations of recognizing they didn't have that authority. So it is a little surprising that it was 6-3, but it is Second Amendment adjacent, so I think that explains the 3. But what I want to amplify before I move on is what this case to me shows is both the importance of Loper-Bright, but also that it's not a left-right issue. Justice Gorsuch made a great point in his concurring opinion in Loper-Bright that, some of the victims of Chevron deference over the years have been immigrants and veterans and Social Security applicants, people who are trying to get benefits out of the federal government. Somebody, some grumpy person in the federal government says, I don't want to give you the benefits, and they rely on Chevron deference to deny the benefits. But this case shows another situation where, what it takes to get Congress to do anything these days is some event that creates some public outcry and some momentum to do something. And if in those circumstances the administration of whichever party can say, oh, wait a second, we don't really want Congress to do something, because once Congress gets going, who knows where they're going to stop. So we'll just try to take all of some momentum out of the legislative process by saying we can actually do this by executive branch fiat. And in this case, it was the Trump administration that yielded to that temptation. So this is not really a left-right issue, but in all events, I think it was a decision where the court correctly reaffirmed that without the statutory authority, this was just something that had to be resolved by Congress.
All right, folks, so there you have it. An excellent presentation by Paul Clement. Always does a great job, and I just wanted you to see someone else talking about these issues, another member of the U.S. Supreme Court Bar, prominent Supreme Court litigator Paul Clement, and I hope you enjoyed that little treat here today at the Four Boxes Diner, and don't forget to subscribe. Make sure you follow me on X at Four Boxes Diner. We have 17,000 followers over there on X, in addition to the subscribers we have here on this channel. And again, we look forward to seeing you soon, real soon, hopefully, here at the Four Boxes Diner.
Orders up. Table 2A.